Thank you. Oh, this works. Okay, I've never worn, this thing before, so just want to make sure it worked. I'm going to talk about trade agreements. That's what I was asked to talk about. A little bit about myself. I live in the United States. I work for an organization, Knowledge Ecology International. We're a small nonprofit organization. We have an office in Geneva. We have an office in Washington, D.C., where I work. We used to have an office in London. We follow a lot of international negotiations, many of them on intellectual property rights, and I'll be talking about that today. I started in a serious way working on these issues about knowledge, goods, copyrights, patents, but other issues around knowledge management goods around 1990 when I was working on issues about access to databases. And at the time in the United States, there was a fair amount of privatization of government databases, and there was a private sector industry. There was companies that were making a lot of money off the databases, such as Reed Elsevier, West Publishing, a host of other companies that would get government databases on patents, on corporate information like corporate disclosure documents, scientific abstracts, labor statistics, all sorts of things. And they'd get them from the US government, and they'd get them in some kind of bulk format. Court opinions was another one. And then they would put them in some commercial database and they'd sell them. And I'd previously worked for a pension fund firm, like a firm that advised people on investments, called the Frank Russell Company. And I was senior economist at the Frank Russell Company. And part of our job was to create products that we could sell to very big investors so they would make less stupid investments in things like real estate. And I had this experience trying to create databases and acquire the databases, and it was really extremely expensive at the time to acquire data, to buy data, to create these products. And then I'd switch jobs. I wasn't working for this, this Wall Street type thing. I was working for Ralph Nader back in 1990. I'd switch jobs. And so he asked me to look at this issue of the government databases. And I was interested in this because it seemed obvious at the time that the value of the information was more valuable the more people had access to it. I'll just give you an example. There was a big crisis in pension funds that invested in a lot of commercial real estate in the 1980s, where they lost billions of dollars in investments, where they'd bought buildings and there was just too many people building buildings and things were going to hell. And so one of the questions people had is why the people that had overbuilt some of these communities and had lost investors' money, including pension funds' money, had not paid attention to the fundamentals. And one of the reasons why for that was because the price of the information about building permits in the United States, about the square foot of building permits, was privatized, and it was owned by one company that had a monopoly in the United States, and they charged really high prices. And so very few people could afford really to look at this basic information. And they had like some little small-time monopoly on building permit data. But the bigger problem was that pension funds had lost billions of dollars. And what they had monopolized were government data that was really issued, statistics from governments and things like that. It may sound like kind of an obscure topic, but it was kind of an eye-opener for me. And at the time, I began to get involved in these issues, and then among other things, began to look at all these other various privatization efforts. And at a certain point in time, when we were winning in the United States, all these, a series of battles of opening up these government databases. This was like 24, like about 20 years ago or more than that, a long time ago. Someone said that there was going to be a treaty in Geneva where they were going to have some European Union had asked for some treaty to create a property right in statistics and data that would kind of undo the victories we were having back then. We were also at the time trying to do issues about patents on government-funded drugs, and someone told a different story, which was that some trade agreement called NAFTA, I was at some Senate meeting, and there was some question about whether the government could override the patents on some drugs, and some senator said he thought you couldn't do it because of some pending trade agreement with Canada. And I was kind of flabbergasted because I'd always thought growing up that, the government was my national government, and they were like all powerful and they could make decisions. And then, it sort of occurred at the time that, no, there was this completely different government out there that I wasn't really aware of, which were these trade agreements between countries. We're beginning to put these, come up with these sort of new super laws that you couldn't even imagine changing. I mean, I started working trying to lobby the US Congress around 1990 on behalf of Ralph Nader and Citizens Movement, and that was difficult, but it was possible back then. You could actually imagine proposing an idea, talking to a member of Congress, having him change the law or do something. But with these trade agreements, another thing that struck me is once they were out there, they were like permanent. I mean, people were still, not completely permanent, but they were much more permanent than a law or even a directive in the European Parliament. Europeans are more sophisticated, I think, than we were at the time, because you'd been dealing with the European Union as this new layer on top of the national government and the attempt to sort of set norms in these areas. And so I think the idea there was something beyond your government was probably already familiar to people, and probably in some ways you'd witness things at a more intimate level at an early stage than a lot of people I knew, including myself, did. But this was kind of a revelation. And since then, I've spent a fair amount of my adult life working on these things. Sorry for the long introduction there. Now, what are the rationale for trade agreements? Well, I think that particularly if you look at sort of the older style agreements that deal with tariffs, for example, and regulatory standards, the old idea was that the whole world can be better off if you collectively lower tariffs and have some standards on regulatory approaches so goods can move in international trade, and you have more economies of scale. But that doesn't really explain the whole intellectual property thing, because intellectual property is not really about the standards per se on our tariffs or manufacturing or anything like that. It has more to do with these other issues. And so there's another feeling that there's certain aspects of economic activity that involve externalities that require global cooperation and norms against free riding. In the patent area, for example. So the idea was that, some countries grant patents, grant the monopoly. The feeling was, if other countries don't do it, then there's not a sufficient inducement for invention. Or the people that subsidize in one country, it basically, they want to make sure that other people are essentially pitching in. That's sort of the basic fundamental idea. And then in the intellectual property area, in the beginning, the intellectual property agreements were kind of a separate type of negotiation than things on tariffs and regulatory standards. So you had things like the Paris Convention in the 19th century, and a lot of this coming out, discussions from Germany and France and the UK, different countries in Europe, trying to basically get some kind of common agreement about how to handle patents within Europe, but also some countries outside of Europe. And then the Berne Convention, also in the 19th century. Eventually other things like plant variety agreements, but these things were agreements that fundamentally were, I wouldn't say they're aspirational. I mean, technically they were legally binding agreements, but between countries, if one country decided to interpret it differently than another, or not even actually implement all the provisions, there was no global police force you could call to bring them to justice. I mean, you had fundamentally, they were sort of, aspirational is really the wrong word. They were harder agreements than that, but they were not enforced as rigorously. And people agreed to them or they didn't agree to them, and you saw kind of they were essentially designed to work through a set of incentives, like the big issue in copyright at the time was the United States didn't recognize European copyrights. And so, the Europeans were not very happy because if their books were being distributed for free in the United States without any payments to royalties. And then, so that would be, one of the agreements, one of the retaliations, I guess, in theory a country could do is they could refuse then, if a country wasn't in agreement with them, not to pay royalties to our authors or something like that. So you could imagine sort of setting up incentives, but fundamentally, that was the old style. Now, this decision to include intellectual property rights in broader trade agreements made the norms much more enforceable. In the WTO, the agreements, the governments, they can and they do litigate IPR disputes between countries. And so Europe, for example, brought a case against Canada because Canada had some exception in its patent law that allowed them to do early work before a patent expired to see if a drug could be made into a generic drug. And Europe brought a case. It was a split decision. They lost most of the case, but they won some narrow part of it. The European Union also brought a case against the United States because we don't pay royalties, certain royalties in bars when music's played in bars in the United States. And it's called the Irish music case by some people. And Europe won that case. And so the U.S. has to pay money now every year. Now, how does the WTO enforce things? It's sort of if the United States or Europe or Germany or Switzerland or India or Brazil or something like that, if they win a case against another country, it's a better speaker than me, I'll tell you. If they win a case, the way that the enforcement through trade agreements, I apologize if some of you are already familiar with this, is that you're allowed to retaliate in a different area. So there was one case where the U.S. had won some case, and they wanted to retaliate by having really high tariffs, so it wiped out the jobs of people that made certain kinds of Shetland sweaters or something like that. So you can target very narrowly a sanction, so you can actually impose discriminatory tariffs on a particular good that really hurts in some politically sensitive way. There's a new area of dispute resolution that's coming up, which is the intellectual property right area. And those are areas, for example, where a small island that won a case against the United States in some dispute about whether the U.S. should honor online casinos was allowed to retaliate by not protecting the intellectual property of U.S. copyrights or patents. And Brazil has pursued this quite a bit because Brazil has a case in some agriculture-related thing where they want to retaliate by the United States by sort of moving against U.S. patented goods or something. So these trade agreements, when you start linking the IPR agreements up to the broader agreements that have, agriculture tariffs, regulatory things and stuff like that, it changed the whole way people thought about these IPR agreements, because at that point the IPR agreements were really enforceable, and you could punish people if they didn't really go along with them. So that was the first generation. Now the new generation is that they now are giving private companies the right to enforce the provisions of the law. Now, if India and the EU have a trade dispute, it's one thing. But if you have a trade dispute with, say, Pfizer, it's a different thing. And the concern that people have is that when you give private companies the right to litigate what's in the trade agreement, that they'll be more aggressive about picking the things that they dispute. Now, what happens in country to country is all countries, if you think of patents and copyrights, they have some exceptions in their backyard. So they're kind of reluctant to really push the envelope and just go for it. Because if they do, it's going to boomerang on them because they have, they may not like our copyright exceptions, but they have their own copyright exceptions. And the same thing on patents. But the private companies, they don't have that big picture. They're just much more aggressive. So that's one of the things that's going on. Now, there's a really significant risk that the trade negotiations get captured by private parties. There's more secrecy, that you find a lot more secrecy in these trade negotiations. You need a domestic policy agreement. The TTIP, which I'll talk about in a second, which is supposed to be a trade agreement between the United States and Europe, it's so secret that if you're a member of the European Parliament, I think you have to go into some kind of room where you're allowed to look at the text but not make copies of it. And you're kind of limited in the stories you can tell after you see the text. And I think that's sort of one issue is that a kind of secrecy is normally not accepted in domestic policy making. But in trade agreements, for historical reasons that are not really completely obvious, particularly in the country-to-country bilateral regional agreements, there's a tremendous amount of secrecy that's typically associated with trade negotiations. Number two, there's this asymmetry of access to information. I mean, I don't think there's very many people in this room that are permitted to see the text of the provisions that have been tabled by the US or the EU in this big trade agreement between our countries. But there's actually hundreds of people in the United States that are in various committees that have the right to see those documents. And many of them work for the same companies and brands that you're familiar with here. So there's this sort of big corporations, they have special access that you don't have access. That's another feature of it. And then you have this big revolving door going on between the people that negotiate the agreements and where they work. Now, just for example, I'm from the United States. Now, the United States Trade Representative, USTR, is our lead trade agency. So one of the person that was the head of intellectual property just resigned, and he's moving to Brussels, where he's going to be working for the motion picture industry of America, Stan McCoy. He was the head of all intellectual property negotiations for several years for the US government. His next job, representing the motion picture industry in Brussels. For people here from Europe, you'll get a chance to know him. He's coming your way. Now, one of his predecessors, his immediate predecessor, is a woman named Victoria Espinel. Now, Victoria Espinel, she worked for the government. She became this head of intellectual property. She left the government, had some corporate clients in a consulting group. One of her jobs was to investigate our group because we were considered to be like a problematic group. Then she got hired back by the government and she became called the IP czar for the US, where she was working in the White House as the IP czar in charge of all these IP policy. And now she's the president of BSA, which is a business software alliance. So now she's sort of gone back and forth. In the ACTA negotiation, a woman named Kira Alvarez used to work for the US government. She left the government. She took a job with Lilly, a pharmaceutical company, where she was a lobbyist. Then she went to work for Time Warner, worked as a copyright lobbyist. Then she came back to the US government right around the time of the economic crash, went back to USTR. She became the lead negotiator for the ACTA agreement for the US government. And now she's back with Abbott Pharmaceuticals. She's gone, or AbbVie, she's gone back to the pharmaceutical industry now that she's left there. I'll throw in something that just involves Europe a little bit here. In the copyright area, the lead IP negotiator for internal market, Marie Martin Pratt, used to work for the recording industry. Her counterpart in the United States is Shira Perlmutter, who works for the Copyright Office. She also used to work for the recording industry. So you now have the top subject matter experts in negotiation for the US and the EU, both having worked for the same organization. I keep forgetting the name of the European version of the RIA, but it's the recording industry. And then the general counsel for the US copyright just quit his job, David Carson, and he's now representing the recording industry. So you have, that's just one example. And I don't want to say these people are bad people. I like all three of those people. They're good people, but it creates a problem. You know, you have people that, like, if their next job is being a corporate lobbyist, what you have to ask yourself, are those people negotiating for you when they go into that negotiation, or are they auditioning for their next job? And I think that's one of the problems we have. And it's a huge problem in the Congress, in the judiciary. I'm not quite sure how it plays out in Brussels. I don't think it's as big of a problem as it is in the United States, but it's probably not zero. Now, I'm going to talk just a little bit about this sort of substantive issues in terms of the policy on this. U.S. patent policy is, I would say, not very coherent. What do I mean by that? Well, in the trade agreements, we're sort of going one way, and it's one cast of characters, but in our domestic policy debate, we're going a different way. And I think Europe has some of the same issues going on right now. So in the trade agreements, we're trying to narrow the permitted exceptions for patentable subject matter. So what I mean by that? I mean, we're trying to make it so, one of the flexibilities you have as a government or as a democracy or whatever is you can decide whether something is patentable in the first place. Like, do you patent something that's a living organism, or something that's found in nature, or a mathematical formula, or a business practices, or software, or surgical methods, or a lot of things like that. There's a whole wide range of areas where it's controversial whether you should even grant patents on certain kinds of things. So one thing that the U.S. is trying to do, and will try and do in its agreement with the European Union in this negotiation, what they'll try and do is they'll try and make it so that Europe has to grant more patents. The problem you're going to have is that the bad U.S. negotiators are likely to be negotiating against an equally bad EU negotiator. So it's not like he's negotiating with you personally, even though he's doing it on your behalf. So that's one of the problems you're going to have. And they're going to do it in secret, so you won't even know what it's done until it's all over, and then they'll just tell you, oh, you have to look at the whole package. And then, you can't pick out things at the end. It's sort of up or down and everything. U.S. wants to have patents on more minor innovations. They don't want to do this argument that you have to have a big leap before you get a patent. They want to make it so small patents. They want to make it easier to file and harder to reject patents. They want to make it harder to override the exclusive right of a patent by granting a compulsory license. They want tougher sanctions, including larger damages for infringement. And they want tougher measures at the border. Now, in the U.S., why do I say that's incoherent? It's because in the United States, it's become harder to get injunctions on patents. We've sort of gone the other direction since 2006. We're now granting more compulsory license than the rest of the world combined. There's a lot of support right now within the business sector, within the judges, within policymakers, within the Congress, for making the damages lower so you pay less money when you're found to infringe on a patent, because people begin to look at patents different now, because businesses are getting sued in the United States all the time for patent infringement, and they're tired of it. And they would they're looking for ways to kind of rein that in, and have for some time. And, so basically, there's also a lot of people would make it harder to get patents and have fewer patents. So why is it that there's one thing happening in the trade agreements and another thing happening in domestic policy? Well, it's because there's really not much connection between the people who do the trade negotiations and the rest of America. I mean, it's like this little separate thing. And you have a bit of a problem like that in Europe, in the sense that there's a disconnect between the people that are your trade negotiators and everybody else. It's some kind of a democracy-free zone. The copyright, what happens here? Well, one of the things that's a big effort, in the US and the EU are both pushing for this. They're trying to push for restrictions on when you can grant exceptions. I don't know how many people here know much about copyright policy or what the three-step test is, but the three steps are basically these three steps which, if taken literally, make it extremely difficult to legislate an exception to some right that you get in copyright. The way it's sort of worked out in the past is you've got these things in some treaties, but nobody really tried to enforce them because only governments could enforce these agreements between each other, and it was rare for them to bring these cases. But the companies continue to push and make every wording of every agreement a little bit different and a little bit worse than the previous agreement, and to cover more things and to be more expansive about this three-step test. And now they're trying to give private companies the right to litigate that and to fine and sanction governments. And that will be in the TTIP. Guaranteed, if you get a TTIP, there will be a bad three-step test. And we don't know yet if there'll be investors' dispute resolution over this, but it's certainly what the US wants, and it's what you do not want. So there's other things, aggressive standards for damage to third-party liability, legal protection for DRMs, longer life protection, just goes on forever. One of the things that's my favorite topics is there's a lot of discussion right now about orphan works that are just basically, because copyright's so long, who can even figure out who the owner is of a lot of photographs you find, a lot of books that are out of print, old newspapers, pamphlets. Now since copyright covers, like a letter, an email to your mother is copyrighted, everything's under copyright these days. You have this massive quantity of historical documents, which nobody could, really has the time, or in some cases the ability to sort of figure out. The records may be gone, you may not be able to figure out who the thing is. So one way to kind of clean this up is to say if you have some copyrighted work that you think is valuable, particularly if it's older, force people to register it as some asset that they want to protect, and then that just sort of eliminates like 99.9% of all the works that are currently covered by copyright that are older. And it would be a big improvement. But the trade agreements are increasingly making it more and more difficult to link the copyrights to the registration. And that's kind of a technical argument, I can get into it. But now, here, I'm going to switch gears a set. These are some trade negotiations that went in the other direction. These are trade negotiations which in theory were designed to address user rights. Now in these agreements, the idea was like, okay, instead of like just promoting like more and more IP or just more, like longer and longer, more patents, et cetera, can you imagine doing things in the opposite way? Well, there have been some negotiations, and I've been involved in 3 of these 5 cases. Now, in the copyright, the first really big negotiation like this was in, I will say that the Berne Convention, until 1971, they used to revise that agreement, periodically, like, I don't know if it was every 10, it depends how you count it, maybe, if you imagine every 10 years to 15 years they were revising the Berne Convention, that would probably be about right. And every time they revised it, they would not only modify the rights, they would modify the exceptions. They created new exceptions, they did all kinds of stuff. But in 1967, developing countries wanted to join the had concluded some long negotiation that started like around 62 or 61 to modify copyright. And the facts were the following. After the Second World War, Asia and African countries became independent. They had all the colonial laws. They weren't quite sure what they wanted to do, so they were trying to, think for themselves. And there was like UNESCO had some copyright convention. What is now WIPO had a different name back then. Had a different copyright thing. They administered the Berne Convention. And developing countries thought, well, maybe we'd have a completely different kind of a copyright. So they proposed. They were interested. They had these conversations. So WIPO was quite keen to have these people join its club and join the Berne Convention. So they proposed a special protocol for developing countries, that only developing countries, and you could have things like shorter, like 25-year copyright terms. You could have, like a rollback on rights. There was all designed to have more access to information, more exceptions, things like that, easier compulsory licensing. The 1967 protocol was pretty good, and the publishers went berserk. They went crazy. And they basically, like particularly in the UK and some Northern European countries really went after this. And so then it was renegotiated in 1971, and the new agreement called the Appendix is, most people don't even know it's there because it's almost never used, is some like really huge part of the Berne Convention with ridiculously complex rules that was designed essentially more to protect the publishers than it was the developing countries. So what you had in 1967 and 71 was an example of kind of a good outcome and a bad outcome in a period of about 4 years in the copyright area. That nobody really did anything like this for quite a long time. And then in 2008, we met with the World Blind Union, and we convened a meeting in Washington, D.C., and we proposed a treaty on copyright exceptions for blind people. Would be like mandatory exceptions for blind people and sort of like capping the rights of the right owner. We would like kind of flip the traditional agreement on the thing. And this was going to be the first treaty that was like a user rights treaty, just for user rights, as a standalone instrument. And that was a really tough negotiation. It took 5 years, but it was concluded successfully last June. There's now, the EU signed it last week in Geneva. There was a big ceremony for that. The US signed it last October. There's now been, I think, something like 64 signatures. And the first day it was open for signature, it had more signatures than any treaty in the history of any intellectual property agreement. So it's gone well. It's a very good treaty, actually. It guarantees that every country that signs it has to provide minimum exceptions, which are pretty good, for blind people in terms of copyrighted works. It provides that you can take a work created in a copyright exception in Europe or the United States or someplace and share it with somebody in another country. So you can take a work created in the United States for a blind person speaking English and share it with somebody in Europe. You can take a work in French and German and other languages, Swedish. So it creates this global system that once you create a work, an exception for blind people, you can share it with anybody in the world. And it was tough, but it succeeded. So then this is sort of like really, one of the reasons there's so much opposition, because this was sort of breaking the mode. The idea that the trade agreements are supposed to be, or the global agreements are normally supposed to be, making things better for publishers, not for users, but just an example where it worked. In patents, there's been 2 negotiations that are significant, one in 2001 and 2003. 2001 agreement, thumbs up, pretty good. 2003 agreement, not so good. So one of the lessons here I just want to point out is if you know what you want to do and you're determined, you're organized, you can actually sort of, I wouldn't say play the same game, because that's maybe game's the wrong word, but you can engage. You can actually use the international negotiations like the publishers or the pharma companies do to sort of address some issue. It can be a different way of looking at things. And I think that's quite important, because one of the things it does is it also deals with the policy space. It kind of shifts the whole conversation. So instead of having 5 years of WIPO trying to do something to basically take away your rights, instead they spent 5 years trying to give rights to people who are blind, and that was like a good change of pace for WIPO. And it was like a kind of a really, it was a good conversation, and it's contributed to other more positive things. Now, so I've got kind of this could be like, if you go to bilaterals.org, you have page after page of trade agreements. There's so many, you could look at the Costa Rica, Canada agreement, or the Korean agreement with Switzerland and 5 other countries, or there's certainly more bilateral agreements than there are people in this room. I mean, they're like a lot, but I've just highlighted a couple here to talk about. So the TTIP is a Trans-Pacific Partnership. This will be huge. This is Japan, the United States, Canada, Mexico, Chile, Malaysia, Australia, New Zealand, some smaller companies. They're talking about the Philippines, this signal they want to join this. And there's discussions in Indonesia. I mean, it's designed to be this sort of super regional trade agreement for the Pacific Ocean. And it has like a spectacularly bad proposals on the IPR front on patents and copyrights. The TTIP is supposedly supposed to be kind of light on the IP. That's the US EU, the TTIP, the transatlantic trade and investment partnership. Is that what it is, the TTIP? That's the EU-US trade agreement. Now, in theory, what the negotiators have said publicly last year on some of the public briefings in Brussels, what they said is, oh, we're going to like have almost no IP chapter because we learned from ACTA. When ACTA embarrassed us and, the Parliament voted it down. So we're not going to do that. We're going to just do an agreement on other trade issues, not involving IPR. But they kind of left the caveat. They said but that depends on what happens in the United States, because they said maybe the U.S. stakeholders, meaning, MPA, pharma, that kind of thing, would want something different. So, in fact, all along, the EU negotiators were planning on having a substantive provisions on the patents and copyright stuff, and they're beginning to work their way through basically a wish list that's presented by these various, more than one wish list by different entities. And so that's important. I would say the EU-India agreement is expected to kind of heat up after the elections are over in India, which is any minute now. And so as the new government takes place in India, everyone's going to see what's going on in India right now, and the EU is going to try and jump it up. Why is that important? Well, it's important because India is the worldwide source of low-cost generic drugs right now. And both the United States and Europe are trying to stop India being a supplier of cheap generic drugs. WIPO Broadcast Treaty. Well, EU is the leader on this. The EU is trying to push the world to create a right. In the old days, copyright didn't go to the authors, it went to printers. We call them printers' privileges. They were monopoly, should give printers for disseminating work, because they did things like, pick the font and put them on paper and publish them and distribute them and disseminate them. The broadcaster right is kind of the same kind of idea. You give an intellectual property right to someone like a radio or TV station because they, make investments and distribute it to the public. And so the theory was, when the Rome Convention was passed in the early 60s after negotiation, they were kind of defined as someone that was like an intermediary between the authors and the listeners, and they had some kind of critical place. You could make the same argument that the grocery store is an intermediary between the farmer and the consumer, or Amazon.com between the author and the consumer, or, et cetera, or Pirate Bay is an intermediary. I mean, it's like, Google, I guess, would be an intermediary in that sense, because Google helps people find information. So then Google could actually ask to be on top of everything else. They could ask to become an intellectual property owner and everybody else's copyrighted work under this kind of theory. And I'm not really saying that to be completely funny, because what's going on at this WIPO negotiation is BBC and the European Broadcasting Union has now said that they don't even really care about radio and television. To them, this negotiation is all about the internet. It's all about delivery of works over the internet. It's all about interactive services. And so people are trying to pin them down and say, what exactly are you trying to do at WIPO? Are you trying to get some intellectual property right for, like, I don't know, running a web page? Is that basically what you're arguing? And where does it stop? And what does that do to the internet as we know? And why aren't people in the room that know something about what you're talking about? And in that negotiation, it's a weird thing. Like David Hammerstein from Brussels, who's been lobbying against this, was there, and he referred to this as a UFO treaty. He said it's like nobody can figure out, everyone has kind of a different idea of what it is. They can't really explain, exactly what it is they want. But the weird thing is that every country that takes a microphone is committed to having a diplomatic conference on this thing, many of them officially next year. I mean, it's insane. There's no agreement on what the right is, how many rights they get, what it applies to, when it stops, when it starts, anything like that. That's a bad agreement. Now, there's some potentially good agreements. WIPO's also been asked to create a mandatory set of exceptions for libraries. Biggest opponent, the treaty discussions blew up last week. At 1:30 in the morning on Saturday morning, because they stopped the clock at midnight and sent the interpreters home, because the EU wanted to challenge the basic mandate of that committee to discuss, without even knowing whether it was going to be a treaty or anything else, even as a model law. They didn't even care at that point. They were not allowed to, they challenged the mandate to discuss anything about library copyright exceptions. And this week, the IFLA, the International Library, the International Federation of Library Associations, they're putting out some singeing, really tough statement against the European Union. And some of their quotes are things like, it takes a lot to make librarians mad, but the EU did it this time, right? So it's like, that's an interesting, because it's potentially, part of what our statement is, we said, look, libraries perform this function in Europe as they're part of the R&D sector. You want to be world-class in knowledge-based goods, you actually want a workforce that knows stuff, businesses that have information. Libraries are more of an important intermediary than TV stations are in getting that kind of information out the door. I'm sure that you have engineers that learn their trigonometry watching television, but I'm joking, because that was sort of an argument about how great TV was going to be for education. But what libraries do, particularly the exceptions they're arguing about, are primarily things that scholars and people trying to do business in different countries and things like that are really talking about. It's not about sending chapter 3 of a romance novel from one country to the other. That's not what they're arguing about. They're arguing about, can you get a copy of an article that you've paid for and share it with a patron? And can you share it with somebody in another country, that kind of thing. So that's an important treaty. The World Health Organization has been asked to negotiate a treaty on how to fund. Am I sort of running out of time here? Is that what that is? Okay, sorry. Yes, I am, yeah. Okay, well, I'm gonna just skip these things right now. Now, here's some data I just wanted to put up here. The European Union published a study, sort of a knockoff of an earlier one by the US, saying all the jobs that you find in the copyright-intensive sector, because they justify their hard line they take in these negotiations because of all the massive jobs that depend on intellectual property rights in Europe. And so they have this report, and they have trademarks one section, patents, copyrights another. I just wanted to show you the copyright section. Now, these are I think it's 34, whatever it is, it's a certain number of businesses. They've identified all of these sectors as the copyright-intensive industries in Europe. And they claim that the existence of all these jobs is why they're pursuing these longer copyright terms, et cetera. I mean, all the sort of hard line they're taking on copyright exceptions and stuff like that, why they're pushing these things. So I went through them and I looked at them, and I put in blue the ones I thought that arguably were stronger copyright protection possibly was of some benefit to the industry, although I kind of doubt that the 70-year copyright term fits that category, but maybe, shrinking the space for exceptions maybe benefits the book publishers, possibly, these things. But these are the number of jobs right here. This is, obviously, it's in thousands. It's not 9 jobs, it's like 9,000 jobs. But what I want to point out is that they're ranked. The top one, other information service activities. Well, I'm not sure what that is, but I'm sure it's not book publishing, because that has a separate listing of 317,000 jobs. But above that are library and archive activities. They have 398,000 jobs. They have more jobs in library and archives than you have publishing books. And then if you take journal publishing, practically dead last, 13,000 jobs. That's what's really driving. These guys are probably more than anything driving the debate right now at WIPO on the issue on exceptions, on copyright exceptions, because they're the ones that are probably impacted the most by it. A lot of these jobs are people that probably have benefited, like web portals. When was the last time a lot of web pages would be everyone would be in jail if you actually seriously looked at what their, the amount of, what the difference between what they do and what the law says, right? So this is what's used by the EU trade officials to argue for more and more copyright, aggressive copyright policies. And it's the same kind of story in the other area. If you look at the patent area right now, The big movement in Europe right now is how to avoid granting an injunction to become more like the United States, how to grant more compulsory licenses on injunction. And Germany's moving this direction. The UK is beginning to kind of understand it has to go. So is the Netherlands, places like that. That's the report. That's just a source document. I'm going to close here. And this is one agreement that we're committed to. We're going to ask we're asking that there be a WTO agreement modeled after the WTO agreement on the supply of services, where countries make voluntary but binding commitments to supply a heterogeneous class of public goods. Because we think there's as much of a global, and more in a lot of cases, globalization issue when it comes to public goods as there is for private goods. And if you think about sharing the global cost of funding research and development on new drugs, if you don't think that just higher drug prices is the be-all and end-all solution, you have to think about these kind of approaches. If you think that cleaning up rivers is important, if you think paying for peacekeeping missions is important, if you think of a lot of things you could classify, not just information goods, but public goods in general, if they're kind of undersupplied at a global level. One of the reasons is there's like super duper ways of enforcing private rights globally, but there's like practically nothing that's binding or has enforcement power that deals with public goods. And this is designed to give public goods basically the same kind of status in the trade negotiation and value and enforcement ability as the other things. I'm sorry for being such a slow talker, but if we have time for any questions, be fine. But you're in charge. I'll let you decide how to handle it. So thank you very much. Except for
soweit James Love. Gibt es noch Fragen vielleicht? Dann einfach Arm heben und ich komme geflogen oder gelaufen, je nachdem. Dort? Ach, dort. Oh.
Hello. In the TTIP agreement, there was a specific part on personal data and how that would be exported to, or should be exported to other countries. And there was a prohibition on making regulation regarding to keep personal data within the boundaries of one jurisdiction. Can you comment on that? Do you have any more information on that? Particularly in the light of surveillance with the Snowden revelations, and what would that eventually lead to?
Yeah, the U.S. is trying to do two things. They're trying to avoid cases where countries require that the data be stored in their own jurisdiction, because people are now aware that the U.S. has complete access and uses complete access to that information, not only to run down al-Qaeda terrorists, but to actually have strategic information about trade negotiations, to give information to firms, to do all sorts of other things that we only partially understand. So a lot of countries are obviously, thinking that maybe having all their email stored in some, in the United States is not such a great idea. That's one aspect, and then the other aspect is that the issue of how that information is sold, how retailers sell that information, how search engines, all those different people. The fact that these are as sensitive, as important as this, you'd have to ask yourself, why is that information, sort of considered like a state secret, what that agreement's going to look like. So I think that that's a very good illustration of why these negotiations should not be secret. But do I have more information about than that? No, I'm sorry. It's secret.
Vielleicht noch eine Frage? Irgendwo? Nee. So thank you very much. I think that's it for now.
Thank you very much.
Thank you.